Let me first start out by introducing our panel. To my far left is Mr. Paul Wolfson. Paul is a partner with Wilmer, Cutler, Pickering, Hale, and Dorr in Washington, D.C. His practice focuses on appellate litigation and on advising clients on complex issues of federal law. Mr. Wolfson has argued 21 cases in the United States Supreme Court and represented Monsanto in the Federal Circuit in the case Bowman v. Monsanto. Mr. Wolfson previously worked in a Solicitor General's office. He received an AB from Harvard and a JD from Yale Law School, where he was the notes editor for the Yale Law Review. After law school, Mr. Wolfson clerked for the Supreme Court Justice Byron White. To his immediate right is Mr. Mark Walters. Mark is a partner with Frommer, Lawrence, and Haug in Seattle. His litigation practice includes copyright, patent, and Lanham Act cases of all kinds, and he maintains an active prosecution docket. Mr. Walters represented the petitioner, Mr. Bowman, in the Bowman v. Monsanto case that we're going to be discussing shortly. He previously worked in a plant genetics lab with the Agricultural Research Service, the primary research arm of the U.S. Department of Agriculture, where he assisted with research projects investigating genetic controls of seed dormancy. Mr. Walters, he is a co-chair of the Federal Circuit Bar Association's Amicus Committee, and he earned his bachelor's from Washington State University and a JD from the University of Idaho College of Law. And to my immediate left, I'm pleased to introduce Mr. Vernon Hugh Bowman. Mr. Bowman was the petitioner in this case in front of the Supreme Court in Bowman v. Monsanto. Before we get into specific questions, let me just sort of set up this case a little bit and provide a few facts and then the holding by the Supreme Court. This case involves patent exhaustion in the context of self-replicating, genetically modified soybean plants developed and patented by Monsanto. Monsanto's soybean plant was called Roundup Ready. The genetic alteration allowed Roundup Ready soybeans to withstand herbicides, so farmers could use herbicides on a field to kill weeds, but not the soybean plants. Monsanto licensed Roundup Ready seed for use by farmers in only one season of use. Mr. Bowman, who was a farmer in Indiana, licensed Roundup Ready seed and used them for one season. He later purchased from a local grain elevator commodity soybeans intended for human and animal consumption, and he planted the commodity soybeans for elite season planting. Some of the commodity soybeans came from plants grown from Roundup Ready seeds licensed to local farmers. Monsanto sued Mr. Bowman for his growth of second-generation Roundup Ready plants from the commodity soybeans derived from licensed first-generation Roundup Ready plants. Mr. Bowman's defense was that Monsanto's patent rights were exhausted after its first sale of Roundup Ready seeds and did not extend to the second-generation seeds or plants. The Supreme Court, in this case, affirmed the Federal Circuit and held that patent exhaustion does not permit a farmer to reproduce patented seeds through planting and harvesting without the patent holder's permission. Such reproduction of new plants constitutes making a new product instead of merely distributing the patented product purchased, and therefore falls outside of exhaustion. So with that as the backdrop, let me first start out with Mr. Bowman. Mr. Bowman, putting aside the merits of the lawsuit, many people probably wouldn't have fought a lawsuit against a corporation such as Monsanto. Why did you decide to keep litigating this case all the way up to the Supreme Court?
Well, first I'd like to ask the audience to show a lot of sympathy for me.
Okay.
Because I'm in here with lawyers and I'm a dumb farmer from southern Indiana. So please tolerate my inefficiencies. Now, back to your question. The reason that I fought the lawsuit was because farmers have a long history of going to the elevator and buying grain to plant. Now, in the last several years, they've used it very little. Only like if you're in the overflow in the river bottoms and the river comes out late, July, 1st of July or late June, and destroys your crop. You might want a cheap product to come back to and hope that you'll just lose less money by using a cheap seed than you would if you left the ground lay idle. And so we've always had that right. It's been that right for hundreds of years. Plus, we use wheat as a cover crop quite often. So about all the wheat used as a cover crop will be purchased at an elevator. You go get it in a fertilizer spreader, spin it on, disc it in, and you've got a crop that'll prevent erosion. Now, if wheat prices would get high and your wheat crop didn't look too bad, you might save it for a cash crop. But that was the main reason, and I fought it because I considered that when Monsanto allowed their farmers to deliver patented or GMO grain to an elevator unannounced, when farmers take their genetic or GMO soybeans to the elevator never asks, are they patented or are they non-patented? They simply dump them all together. Mm-hmm. So I considered that Monsanto claiming that I was infringing was, in a sense, forcing their patent on me, because they should have, if they didn't want me to go to the elevator and buy grain out of the bin, then they should have had their farmers to sell that grain to elevators that agreed to keep it separate. Mm-hmm. And they shouldn't have been allowed to dump them in with common grain and then say, now that we have dumped them in with common grain, you can no longer use that common grain as seed. Plus, as I understood it, there was a law, a patent law that said utility patents have to be marked. In other words, you can't sell a pair of pliers to the public and claim patent rights unless you put the patent number on them. Now, in the case of soybeans, you can't patent individual beans. You have to patent a bag, or you patent a container, or even a bin. And you would put a tag on the bin that says these are patented beans, you can't use them. But none of the beans that I bought from an elevator had any patent, weren't marked patent. And so it just seemed to me that it was a natural thing for me to go to the elevator and use those beans and hope that they were Roundup ready, because all the farmers in the area, I knew hauled a bunch of beans in there. So I thought, well, I'll get these beans, and if they're Roundup ready, that'll be an advantage. And if they're not, then I'll have to use traditional chemicals on them. And that's pretty well the reason that I fought them so hard, is because I felt that I'd done nothing wrong.
Mm-hmm. Okay. And Mark, to follow up on that point, Mark, you represented Mr. Bowman at the Supreme Court. The court's decision hinges on classifying this second generation of seed plants as a creation of a new product, which falls outside the principles of exhaustion. That's what the Supreme Court said. In your view, what's wrong with the court's analysis?
Well, first, I would disagree a little bit with the question, in that in the case of a seed where the invention is meant to be planted and to create more items that are substantially the same as the first that was purchased, that is part of the invention. And so we tried to get the court to focus on that aspect of self-replicating technologies. This is not simply an item that you purchase, you use it till it's exhausted, till its useful life terminates. This is an item that you purchase, and in the course of using it, it actually produces more items of itself. And so this fact that they could avoid addressing exhaustion by simply saying, oh, well, this is a separate item, this is the one that wasn't sold, I thought was one of the major problems of the analysis. Because you have quanta essentially saying that when an item is sold that embodies a patented method, then the method claims are exhausted along with the apparatus claims and the system claims. So we had methods of planting here that were at issue, and certainly the methods of planting and farming in a way that you spray this herbicide over the top of the plant and the plant survives that application of herbicide is a new way of farming, and there certainly were claims at issue in this case that dealt with the planting and the harvesting of these seeds after applying glyphosate. So you have a situation where Mr. Bowman bought these seeds free of any restrictions as to what he could do with them, and used them for his intended purpose, which was to plant a second crop. And he now no longer has the benefit of the exhaustion law, which does applies to those method claims. He can't exercise that right to use this item in the way he intended to use it. So that was the main issue and the main analytical problem I see with the court's analysis.
Okay, and just to sort of follow up that comment, from listening to your oral argument, it seemed like a lot of the questions from the court was directed to the other uses of the seeds. It seemed like to me they were conflating, uses for consumption versus uses for replanting, and it seemed that they didn't focus necessarily on the claim itself, as you just addressed.
Yeah,
is that part of the problem?
Exactly, and exhaustion is all about a right for the purchaser to use the invention,
right,
and not use it to make a tofu turkey, like Justice Breyer
right.
discussed, but use of the item that's sold to practice the invention. And that's planting this seed, applying the herbicide, and letting it grow. And to me, that was a very clear problem with the analysis of the court, and puts this case, in my opinion, in direct conflict with quanta. And it shows how important the policy arguments are at the Supreme Court level, because we had some great legal arguments, but in the end, I feel like Monsanto was very effective at rallying basically the entire biotechnology industry, all the universities, and a handful of other interested parties against this real, clean legal argument. And then on our side, on the policy side, we had, difficulties in getting, our voice heard. I mean, this is really a small farmer problem. It's not big farmers. I mean, the big farmers were on Monsanto's side, but the small farmers aren't necessarily organized in a way to have a lot of influence on the court. So, big lesson for me how important these policy arguments are at that level.
Okay. Mr. Wolfson, let's hear from you. From Monsanto's position, why do you think the Supreme Court got it right in this case?
Well, I think the court really understood that the question was, what would be the value of the patent if immediately upon using the product to create a copy of itself, you would be unable to obtain any value from the patent in any of the subsequent generations. And you really do have a situation, I think, where there's a significant problem with the patentee basically putting itself out of business by launching the product into the marketplace. And as Chief Justice Roberts asked my brother here, at oral argument, why on earth would anybody expend all the time and the resources into creating into developing an invention that would lose its value, immediately upon, being adopted. Now, you can quibble with that or quarrel with the assumptions underlying that argument, but I think clearly, unlike quanta, which the court basically didn't touch much, either in oral argument or certainly in the opinion, and kind of left where it was before with a lot of questions about what quanta means, and we can talk about why it did that. I think really the court felt that this is sort of not a case like quanta at all. This is really a case in which I mean, yes, it's true, you may be using the seeds to do something, but just by the nature of it, you are also making the product once again. And you know, exhaustion never applies to making. And if you want to make a new product, you always have to have authorization from the patent holder to do that. And although this kind of what has come to be called as self-replicating technology, although I don't like that term, but people, you know, I probably have used it many times. Although this case involves separate self-replicating technology, it's really not that different from when you're basically taking two products and making a new one or something like that. You know, you are using something, but you are also making something new. And so I think the court really understood that if it went the other way, it was going to be placing a big question mark over the value of patents in, you know, in biotechnology, things that are incredibly important to our economy today. I also think it's interesting to note that even though the court endorsed Monsanto's position, it actually didn't say, you know, we had a lot of discussion earlier this morning about courts never wanting to say never. And I think courts also never want to say always, you know. And so the court did say, look, we recognize that these are new technologies to us. And so we're not saying that in every possible situation where the self-replicating technology is, you know, used to create itself, that there's no exhaustion. You know, we're going to look at these cases as they come to us, because, we may not fully understand all of the implications. So I think there probably are, issues to be worked out in the future, but I think for these kind of uses for biotechnology, the court really understood, what was at stake.
Mm-hmm. Okay. And I think you answered part of my next question, and that relates to the self-replicating aspects of this particular product. The court expressly declined to address whether the doctrine of patent exhaustion would apply to circumstances in which the Roundup plants would self-replicate on their own in nature, outside of the purchaser's control. How do you think the exhaustion should be analyzed in those contexts?
Well, I mean, I think it sort of, we have to sort of think a lot about what the exact fact pattern, would be. I mean, I definitely think that the concept of making, implies, an element of human agency. I mean, certainly that's how we, we very much rejected the proposition that basically all that happened was that kind of the soybeans were being, thrown into the ground, and basically nature was doing the rest of the work for it. I mean, a huge amount of application of, human effort, resources, time, and so forth, it goes into farming. Now, in a situation where the farmer takes no action to cultivate a seed, well, then you might have to think about, does the farmer then use it or sell it? Is the farmer using it or sell it? That would be an infringing act. But I think the important, what you have to kind of step back and all that from that and to say is, when you're talking about a farmer who doesn't want to use the patented product, a farmer who doesn't want to use GMO crops, I mean, why on earth would there ever be an infringement action brought against such a farmer? I know there are people who say, that that's a possibility, but I think you have to kind of separate here kind of what might, technically or theoretically be made as a patent claim from what is, actually going to happen. I mean, this case and does involve, a farmer who did want to make use of the patented invention, and his position was the law allowed him to do that, and that's fine. But this isn't a situation where the farmer is sort of accidentally, where the farmer has the invention really foisted upon him accidentally. Mm-hmm. So, I can certainly make arguments that would be an infringing act, but I think one has to ask how would that infringement lawsuit ever be brought, and why would it ever be brought?
Mm-hmm. Mark, do you have any comments to that?
Well, I think I've got a lot of comments to the statements. One thing I'd like to hear is Mr. Bowman's response to the argument that by going to the grain elevator for your second crop, you would put Monsanto out of business. What do you think about that?
Well, I think that would be absolutely ridiculous, because I thought that Judge Roberts should have asked you, why did Bowman, all these years that he was infringing, why did he go to his seed dealer and buy Pioneer seed, labeled and patented seed, for his first crop? He never, if elevator seed was such a good product, why didn't I use that elevator seed on all of my soybeans instead of just my second crop, which is a risky crop that Purdue says yields only 60% of first crop beans? And so why did I buy that high quality seed when I had all this wonderful junk seed, I called it, but all this wonderful seed at the elevator for a fraction of the cost? And so I don't think it would have hurt them a bit, because we had a big flourishing seed business before Monsanto come out with GMO. It was a hell of a big business. And farmers then could always go to the elevator and buy grain and plant it if they wanted to, but they didn't want that junk seed. So I feel what he is claiming there is completely out of line. So that's all I've got to say.
I'll just I'll follow up a little bit. I mean, this is an issue that we tried to get the court to focus on. That really what we're talking about here is a farmer that wants to use grain elevator seed, which is inferior to first generation seed that's labeled and of a uniform variety. And really all the first generation seed that's patented is sold marked in bags with agreements that farmers sign where they agree not to save the progeny and replant it. And that's why Mr. Bowman didn't save and reuse his Pioneer seed that he bought for his second crop planting. And I think by and large, most farmers think about this as a contract. They don't think about patent laws being used in a way that could come out of nowhere and sort of surprise them. And I think the court, more towards your question, was struggling with this innocent infringer scenario, because there isn't an intent element in patent law. It's infringement is a strict liability offense, and de minimis infringement is still infringement. And you sort of have to rely on statements made by Monsanto that they're not going to prosecute certain kinds of people who might find themselves infringing the patent. But I think that they were trying to reconcile that in their opinion. And of course, that wasn't our case. So we couldn't really hit that very hard in our briefs. But there were some amici who filed briefs about what kind of impact is this going to have on the innocent infringers. But I think it is an outstanding issue. I think that the courts in the future may have to struggle against that. There have been cases like of Percy Schmeiser in Canada, who his canola crop was contaminated with GMO. He noticed that it became contaminated and decided to take benefit of that and applied Roundup to it. And over successive years, built up a stable gene pool that he could use. But that was an infringement, even though he had not done anything necessarily to invite the first instance of contamination. Simply used what was his personal property in any resourceful way that a farmer does use that property.
Mark, I've got to correct you.
Okay.
Schmeiser never used Roundup on that grain.
Right.
It got out in there, and he never used Roundup on any of that grain. And the Supreme Court of Canada said that they didn't give Monsanto any damages reward because they said he didn't benefit from it. So I had to
Well, that's
correct you there. But And one question when you're talking about how the seed would be, I have a list here from my pioneer seed salesman as to why he would argue against a farmer going to the elevator. Okay. And here are some things. You don't know the germination, you don't know the genetics, you don't know the history, ag contamination and foreign material, you don't know the quality, you don't know the blend of soybean sizes, you don't know the maturity, you don't know the characteristics, and you don't know the disease package.
But see, respectfully, I mean, I agree with all of that, and that's why, to me, I think that the court had some trouble with the notion that farmers have been buying seed for time immemorial from the grain elevators, because the grain elevators themselves, the Association of Grain Elevators themselves filed an amicus brief and said, that's not really our experience. Our experience, now I'm talking about soybeans, our experience is that we are, collecting soybeans, from a huge variety of, farms in our area, and this is the commercial channel. And what happens is, like, giant rail cars come and we dump our soybeans into them, and our custom is not to, sell to individual farmers who, want to replant, because it doesn't make, any economic sense for them to do that, as opposed to, saving their own seed, which of course they are not allowed to do under the, Monsanto agreement. So, I mean, I always thought that from the notion that what kind of Monsanto is trying to do here, or what somebody in its position is trying to do here, is kind of stop something that farmers have been doing since time immemorial, was really, it was really not correct, or not supported by what my investigation of the circumstances make. And this is a situation where farmers understand that they want to take advantage of the Roundup Ready trait because it's tremendously beneficial to them. And to me, nobody doubts that. I mean, well, people do doubt, but for present purposes, it isn't doubted that, Monsanto could say to a farmer, you can't save your own seed for, replanting. Monsanto can say, we're not going to sell you if you and the farmer next door are if you're going to sell your surplus to the farmer next door. You can't kind of exchange soybeans over the fence, and do that. So I've always been kind of mystified about what sort of magic about the grain elevator, that makes this kind of different, makes this case different from that case. And I think both the Federal Circuit and the Supreme Court were of the same view. That is, there really isn't you really can't draw a line, that will say, this kind of saving and replanting seed is okay, but that kind of saving and replanting seed is not okay. So it really has to be kind of all one or all the other. And I think that looking at that choice, where the court came down was the right answer.
I'll just briefly, I don't know who the Association of Grain Elevators are, but I'm pretty sure they don't include the types of grain elevators that are in local rural communities, and there are hundreds of thousands of those that very often sell to people like Mr. Bowman.
The big terminals are not going to. I can't pull in there and say I want 50 bushels of seed in your fertilizer cart. I can't bother. They don't have them, so they're not likely to sell to me. Mm-hmm. But the small elevators sell me. They buy my grain. They may even sell me seed. They may sell me fertilizer, and we do a lot of business. So to accommodate a farmer, they're perfectly willing to sell him seed out of the elevator to use. Now, one thing that who was Pioneer said in their brief, they explained in their brief that it was illegal. It was completely illegal for me to go to the elevator and buy grain because the federal and state laws prevented it. That was completely untrue. The state and federal laws prevents the elevator from going to those grain bins, even before Roundup Ready was on the market. It prevented them from going to the grain bins and then cleaning that seed and selling it to me as seed. The elevator can't do that. That's against the law. But some confuse that with the fact that I can just go buy outbound grain, which was what the elevator sold me. They sold me outbound grain. And when the person, what's your name again? Paul. When Paul said that I could, well, now I've lost my, when I asked you your name, I lost my train of thought. See, now I want sympathy from you people. But anyway, well, shoot. Where was I at, Mark?
You were talking about, those laws, those arguments were made by Pioneer.
Yeah.
And they were misleading, but I think the court got that.
Oh, when he said that I wanted the Roundup seed, that I did. I hoped that it was high concentration of Roundup seed so I could use Roundup. But had it not been, then I would have used it anyway and used conventional chemicals on it. So it wasn't a must that I had to have this cheap seed with Roundup Ready traits, but it was a must that I have cheap seed as far as I was concerned. Do you understand the difference? Okay. Yeah. All right.
And I think one other thing is it's not just trade from a grain elevator. I mean, there are a number of different ways in which seeds are going to be available to the public for purchase and to farmers for purchase at open markets. And essentially, when you buy seed in this way, you have to either be sort of a geneticist and a patent lawyer and a farmer to figure out if you're going to be free of liability. It's not enough now to rely on the exhaustion law, which has been a part of commercial law for over 400 years. When you buy an item free of any restriction, you're free to use that item in the purpose that it's fit to be used until its useful life is terminated. You certainly can't reconstruct it after that, but you certainly can put it into use for whatever purpose it was bought.
Paul, do you have any comments to that?
Not at the moment.
Okay. Well, here's sort of a slightly different situation. Say, for example, these patented seeds were, obtained from a farmer, not knowing. Meaning, say the seeds happen to blow onto your land, for example, and they were, somehow got in the soil, they grew. Now you have these GMO seeds that are growing naturally.
Yeah.
Do you think the court, this is for any one of you, would have reached a different conclusion as opposed to Mr. Bowman actually actively going and purchasing seeds for planting?
I myself has wondered what they do. I don't know who owns that blows over on a farmer's land. And now a good example of that, the best known method of GMO seeds getting onto a farmer accidentally is through corn. Because corn, the pollen is drifted by the wind, and so if I have a field of non-GMO corn and the neighbor has a field of GMO corn next to it, there's going to be an awfully lot of corn out there that will have the GMO traits. Now, I have wondered, of course, it's complicated. A farmer is not going to go out and get that corn and plant it next year due to the hybrid situation. But anyway, I have wondered what would happen if a farmer or a plant breeder was to own ground. He took that grain that he knew was GMO, and then he developed his own hybrid through a long process. Would he be infringing? I've kind of thought probably he would, but I don't. I've wondered about what in the world that would cause. That could cause a real big problem. And I think then is where we need congressional. The Congress needs to come in and pass some laws explaining that before lawsuits take place. That was my case with Monsanto. If Congress had to come in and said, now, Bowman, since there is a lot of Roundup Ready beans in elevators, in your local elevators, you can now no longer go buy that. Then I would have been in violation of the law. But no laws had been passed as of that time, and so I just think of course, all losers will talk that way, you know that. But I think that the Supreme Court pulled a big blunder.
Mark, do you have any thoughts?
No, not on that in particular.
Paul?
Well, I mean, let's separate two different circumstances. One is the kind of the person who unknowingly, supposedly, it's not really, supposedly the GMO blows onto his land and he has no idea what's going on, and, he cultivates it and sells it. That, I mean, I don't, understand where the infringement case is going to be brought. Then, you're postulating a different circumstance where it happens by accident and somebody sees it as happening and thinks, oh, guess what? I've got a great opportunity here. I'm gonna make an advantage out of this situation. Totally seems like the equities are totally different to me. I mean, there was a reference made earlier this morning in the already case, to the organic seed growers lawsuit against Monsanto, where a group of organic and conventional seed growers who do not want to grow GMO crops brought a lawsuit against Monsanto seeking to invalidate Monsanto's patents on basically every possible theory you could think of. And Monsanto's response was like, we have no idea who you people are. Why are you suing us? We don't want to sue you. Why do you possibly claim that you're in danger of a patent infringement liability? And both the Southern District of New York and the Federal Circuit ruled that there was no case or controversy sufficient for Article III jurisdiction on slightly different grounds. As mention was made, the Federal Circuit, the Southern District more ruled on the notion that there was kind of no real kind of threat of, any assertion of the patent. The Federal Circuit ruled more on the grounds that Monsanto had a publicly announced policy that it would not enforce its patent against somebody a farmer who had suffered, inadvertent, who was sort of where the presence of the genes in the farmer's crops were sort of as a result of adventitious or inadvertent gene drift, and where it was a trace amount, which the Federal Circuit interpreted to mean was 1% or less of the presence in the farmer's fields. And the Federal Circuit said, well, none of these people have claimed that they have suffered or are at risk of suffering more than 1% gene drift, so no case or controversy. Those farmers, the organic farmers, who are represented by the Public Patent Foundation, have actually filed a cert petition in the Supreme Court just a couple of weeks ago. So we're in the process of responding to that cert petition. So, this issue is one that has been kind of out there and has been discussed, and there's a kind of well-known concurrence by Judge Gallarza raising the issue. But no one's ever pointed to it like actually being a real live possibility of this kind of infringement lawsuit. And I think I've yet to be persuaded that it really is.
There's no question after this case that if you plant a patented seed, no matter where you got that seed, even if you bought it on the open market like Mr. Bowman did, if you plant that seed, you're infringing the patent. It's just the question of whether Monsanto is going to sue for it and what kind of damages might be there.
Okay. I'd like to take this opportunity to have the audience ask any specific questions they might have of the panel. Yep, there's one over here. I think we're going to pass over a microphone.
Mr. Bowman, the
Yes.
question I have for you is there anywhere that you could buy the conventional seed if what you wanted to do was to have the inexpensive seed, or has the result of widespread use of this resulted in the elimination of the source?
I could have bought conventional seed, but it's still pretty high. It's within $7, whatever the tech fee is. It's within $7 of the high price seed. So I didn't want non-GMO regular seed at the high price. I wanted a cheap seed. See, historically, before Roundup Ready came on the market, I had a farmer neighbor who sold, I forget the name of the seed, but he sold this seed, regular high quality soybean seed. But when you planted it after June the 20th or following wheat, he cut the price in half. So I was able to use high quality seed at half price. Now, where I go now for my double crop seed, I save it, but I get it from Ohio certified, which you're allowed to save and keep that. So I bought Ohio certified seed, plant it, and then keep it, and hopefully I can. Now last year, my double crop beans made a half a bushel to the acre. Well, that's far from the record of 160. But anyway, this year, due to the drought that we had after a wet spring, I'm afraid my double crop beans may not produce enough to give me seed for next year, so I'll have to go buy high quality seed again for my double crop next year. So now, have I answered your question, or have I beat around the bush?
I think you've answered my question. I would have thought that if there was this alternative source that you had available to you, that would have been part of your defense of the case, that you weren't really looking to benefit from the patented characteristic. This is just a convenient source of the cheap generic seed.
Well, I was when I bought that seed from the elevator, I was hoping it had a high percent of GMO. I won't argue that because it made it more convenient. But I would have used, if it would have been only 10%, why, I would have used it anyway and used conventional. But you can go buy conventional seeds. Now, some conventional seeds you aren't allowed to save, and that's, I'm not clear on that, but the Private Variety Protection Act came out so that farmers, when they bought this high-quality seed, not non-patented, but high-quality seed, they could save it for themselves, but they couldn't sell it to their neighbors. But now, the last time I bought some, when we were planting it, I got to reading the label real close, and it said I couldn't save it. So I called the guy who sold it to me and asked him what was going on. And he said, oh, you can save it. I said, that's not what my seed tag said. And so I said, you better check and see. And he called me, or later I was talking to him, and he said, no, you're not allowed to keep that. And so I don't know whether they inserted some other little patent in it or what they done, but there's an awful lot of what we used to call Private Variety Protection Act beans that you could save, you can't save them now. So about the only source I know of is Ohio State right now. They have public varieties. So any other
questions?
This question is for Paul. Mark suggested that the big farmers, respect the licenses and are not trying to buy the seed in the grain elevator, and it's really the small farmers that are doing it. And if that's the case, then why doesn't Monsanto just charge more for the first seed they sell, let the small farmers continue to utilize the second generation seed? And it seems like if the small farmers are abiding by the license for the first generation, it doesn't seem to me to be that huge a problem of copying the seed, and just maybe charge more for those small farmers to begin with and let them do what they want afterwards.
Well, I don't personally know that that's the case, that it divides up between big farmers and small farmers. I mean, especially with soybeans, obviously the rate of adoption of Roundup Ready is, astronomical and, incredibly quick. I mean, it's probably one of the most rapid adoptions of a new technology that we've ever experienced, I think the judgment is, first of all, I don't know how you distinguish, between new farmers and small farmers when you're making, kind of a commercial, when you're, making a commercial deal like that. I mean, the product is available for, for anybody to buy, right? I mean, you go to a seed store. I mean, the seed store is not going to say, what's the size of your farm? And if you're under, 30 acres, I'm going to charge you a lot less. But if you're, that doesn't seem to me kind of a very, promising way to, way to commercialize. I mean, I understand the point, but in the end, I think, the judgment is the amount that you would have to charge for the technology in, generation 0 in order to make sure that you could recoup your investment would be astronomical, and not something, not something that any farmer, big or small, would want to pay. So, I think why not kind of make it readily available, and make it. I mean, it is more expensive than seed used to be, but on the other hand, farmers have adopted it for a reason. There was some resistance, at first, because farmers said, "Wow, why am I paying $7 a more bag for for seed that I can only use once, right? That doesn't make sense." And they tried it out and they really liked it. So I just don't see that you can make that kind of market differentiation that's practical.
I'd like to comment on that. I'll have to disagree some with my friend here. Around home, it doesn't matter what size farmer they are. If they lose a crop in the river bottom, they may very well go to the elevator. Now, some don't, because they feel that a high quality seed, even in risky situations, is worth it. That's like down home, ground is selling for up to $14,000 an acre. There's an awful lot of farmers think that's ridiculously high, but there are some farmers that think that's all right to buy because they're paying that price. And so I think that in my case with double crop, I think some farmers wanted to use the high quality Roundup Ready seed to plant because they thought it was better and they would benefit from it. I just thought it was too risky. So I kind of agree with Paul there on that. I don't know how you handle that thing of what size farm you got. I mean,
well, I'm just trying to explain why the Association of Soybean Farmers supports Monsanto.
That's what. Yeah, they done that, and they were wrong. I think. Yeah. They weren't right.
Are there any other questions? Yes.
Mr. Bowman, are there any grain elevators that you are aware of that will separate the GMO grain from the non-GMO grain?
Yes. What happens is that it's more apt to happen at a big terminal where their foreign market wants non-GMO seeds for food. They don't want GMO in there. So some of these big elevators, and of course there could be smaller ones too, but they buy non-GMO seed. A farmer has to certify that they're non-GMO seeds, and they test them when they come in. There's a quick little test they can do to see if they're Roundup Ready. So they'll test them, and if they're certain percent, and it's got to be pretty small, if it gets up there very much at all, they'll reject that seed and won't take it and pay a premium. So there are elevators who do keep it separated, but it's mostly big terminals. Now, I don't know of any small local elevators that are doing that, but I know of some farmers who are contracting with big elevators to furnish them non-GMO grain. Does that answer?
Yeah, so when they get the non-GMO grain from the big terminals, are those farmers then able to use that as a second crop in the year, as seed for the second crop?
Could they? They probably, well, I think they could, but the elevator might not want go out and fool with like 200 bushel will plant 200 acres. So they might not want to fool with a little farmer coming in and getting that. And then again, the elevator that I bought my seed off of, I may have to sue them to buy commodity seed again because they're afraid of Monsanto, and they've told me they won't sell me any more seed.
Okay.
So I don't, the big terminals, I don't know if they sell to farmers or not. I've got the feeling they don't sell to farmers to buy a small amount to seed or even to feed to their animals, like a truckload. I can't comment on that very.
Thank you, Mr. Bowman. I have one further question, actually for you, Paul. Could Monsanto avoid a lot of these problems by licensing the seed instead of selling it per bag? Sell it per acre that the farmer is going to plant, and say that they can use the seed and second generations during one season only, so that if the farmer wants to plant a second crop, he would be able to do so and have it already priced in, so that he would be able to do that.
I mean, I think that's sort of related to the question that Ed asked, a minute ago. I think the judgment is that of course, you're not really just authorizing it for the second season. You're authorizing it for the third season and the fourth season and the fifth season and the sixth season, as a practical matter. I mean...
well, by contract, you could say that you were going to allow it only for the one season. So it's licensed for one calendar year, for example, or 6 months or something of that nature.
I think the problem is whenever you sort of are thinking, what is the price going to be for kind of allowing somebody to kind of take control of your own invention and basically make it themselves, you get into to me, a very kind of precarious situation. And I think that's exactly what the Supreme Court was reacting to.
As Mr. Bowman spoke, the farmers are trying to abide by the contracts, and so if the contract said that not to use it, they don't use it in the second year.
But the vast majority of farmers do abide by the contracts. I mean, the number of not just Monsanto, but the number of disputes that companies like Monsanto have with their farmer customers is actually really tiny. So they do. I mean.
All right, thank you very much.
They like it the way that it, farmers do like it the way it is.
Well, one quick question. We're at our stopping point.
All right. Hi, this is a question for everyone. It's my understanding that the patents at issue will expire next year? Is it? Or
there's one patent, the reissue will expire next year, I believe.
I thought one was 2015, but anyway. Yeah.
But either way, at some point in the not-so-distant future, we'll have 3 classes of seed. Non-GMO seed, GMO seed where farmers are actually allowed to use Roundup because they're now generic GMO seed. And then GMO seed that contains additional advancement where there will be covered under future patent. What is how would this marketplace evolve so that we can that farmers like Bowman may in 2 years go back to buy grain elevator seed and start using Roundup without to practice the generic seed without running afoul of Monsanto's future patents? Thank you.
Just answer very quickly. I think there's a practical difficulty in identifying and separating those seeds from the grain elevator. But secondly, I think there's very much a question as soon as these seeds go off patent, whether or not those particular varieties, unpatented varieties, are going to be preserved and maintained with the Department of Agriculture in a way that would permit the creation of a generic market for seeds. Farmers traditionally will buy from branded sources because they want to know where their seed comes from. It's really important to them that they have certain characteristics and quality. and the creation of a pure generic type of market for seeds like we have in the pharmaceutical industry, I think there's some question whether or not that's going to happen in exactly the same way.
I think we'll have to see. I certainly agree that a lot of farmers want to buy, the latest brands, and they're very attentive to, improvements in brand quality and so forth. But, some farmers may find it to their advantage to not do so, and I think the market will work that out.
Well, I'll make a comment. A seed cleaner that I had years ago that come around and cleaned seed told me before he quit that his seed business had dropped off drastically, cleaning seed, because new varieties were always coming on the market that increased the yield or made it easier to farm. So the farmers tried to stay up with the latest. Now, Monsanto has a bean coming out with dicambia. It's a kind of like 2,4-D, but used to it would kill any bean it touched, but now they're getting a bean that dicambia won't kill, and it's going to be needed pretty bad because Roundup Ready beans are running into a problem with resistant weeds, and these resistant weeds are taking over. So when Monsanto comes out with dicambia beans that they can spray on top and kill all those resistant beans, that's what they're going to do. They're not going to want the old Roundup technology, I don't think. But now does that help you any?
And
okay.
Let me be the first to thank our panel this afternoon. I appreciate it. Thank you. Very nice job.
Well,